May it please the court. Andrew Beamer for Samantha Yarborough, the mother. I don't know how the court would handle this, but I do believe most of my arguments carry over. As such, I'm going to just be very brief and say.
You want to reserve any time for?
I would reserve 3 minutes if necessary.
3 minutes, that'd be
but
fine.
I don't believe.
And we understand that the argument's kind of.
Yes. I would just to clarify the export issue a bit. The issue was more than just the licensure to the part-time. It was also the time frame. She received her degrees years ago. She didn't practice. The testimony was that she worked as a personal assistant for a while. She did no therapy. And as such, I think when looking at the totality of the evidence, that she was not an expert. Further, there was the issue I raised at the trial was the ethics. Now, me and the appellee probably disagree a little bit on that, because I think if you read her testimony from that, it was clear that she was not very clear on what her ethics were, who her client was, what her job was as the family therapist. And those were some of the objections I raised at the trial about her being an expert, about her being certified as an expert. She also clearly stated at the trial court level that she could not give any recommendations for custody, which I think which is also a question from someone who is being certified as an expert for purposes of custody. So I would just state, I do think it was an abuse of discretion that she was made an expert. I do not believe Ms. Gray was an expert under those circumstances. I do understand that that's a high burden, that trial courts, generally speaking, they have a lot of discretion in this regard. But I do believe if you look at the totality of the evidence that Ms. Gray should never have been certified as an expert.
Who testified regarding the behavior of the mother?
Ms. Gray testified regarding the visitation. She was being the family therapist and the supervising person of the mother.
And it's your position that her testimony should not have been admitted?
Not as an expert. Now, I'm not saying some of her testimony, her personal testimony of what she witnessed, I think can come in, absolutely. But I think that her giving expert opinions should not have been allowed. So that, yeah, I don't have any. I think she was a fact witness to what she saw. I don't believe that that's a problem. And just to state as far as to the
testimony from this child that if he continued to have visitation with mother, that he would actually kill himself. Where did that testimony come from? Was it from the child, or was it from Ms. Ray?
I believe that might have been from the child, but I honestly, Your Honor, this was 3 years ago, and I do not know the exact answer to that, and I don't actually have those 5 days, I did not have that transcript directly in front of me. That might have come from the child who was testifying at that time. I'm not completely sure to that. There were some issues in the visitation that she testified to, but that goes back into another issue, which was when she stopped the visitation, there was a major issue of why visitation was stopped and the juvenile court order and how that was interconnected and who stopped it, which, like, as I stated, I guess in my prior argument was, these are always problems when you're moving from one court to another court and you have actions that are happening in the trial court, in this situation, in juvenile court, and then you're having determinations in chancery court, especially when there's absolutely different counsel at all levels. So there was some issues with that, because I believe the testimony was that the guardian ad litem in the juvenile court told Ms. Gray that she could stop the visitation, but there wasn't a court order to that effect, at which point my client filed for return of custody, then the Grays filed for termination, and I believe Chancellor Haggerty issued an order like staying the orders from juvenile for a minute so that they could try. It's like there was a lot of confusion in that of the juvenile to chancery court and how it operated for visitation. which is one reason why I do believe the abandonment is unclear, is because I think the evidence for abandonment is quite unclear. But a large part of that has to do with, like, as is the moving of the court systems and moving from one order from a judge to another order of a judge, and how that interplays on top of COVID, which obviously was also at play in this situation. So there was a lot of time that would be like lapsing, and it would be unclear if the court order from Anderson County, it was just, there was very much confusion on that issue. But honestly, Your Honor, I believe that is all. I think my argument from the other would stand, and so I'll rest.
Thank you. Hear from the appellees.
Whitson Smith, Your Honor, representing the appellees in this matter. Just to address the ethical issue raised by the appellant regarding Ms. Gray's qualifications, I cited to it in my brief. Ms. Gray specifically testified that she was familiar with the ethical rules of her profession. She clearly stated that her role as a family therapist with the children was that she was doing therapy to determine, quote, if continued contact with the mother was going to be safe for my clients, referencing the children. And, you know, at this point, I did not reference it in my initial argument, but I think it would be beneficial to highlight some of the mother's conduct in the family therapy sessions that was testified to by Ms. Gray. Ms. Gray testified that the mother pulled her pants down during one of the family therapy sessions to show a tattoo to her children. The mother accepted FaceTime phone calls during the family therapy sessions. And to Your Honor's question for appellant earlier, my understanding is that Kaniel told Ms. Gray, the therapist, that he would kill himself if he had to continue family therapy sessions. I believe that's where that testimony came from. And then Kaniel
Ms. Ray was the one who testified about the mother pulling her pants down to show the tattoo, and about taking phone calls.
Yes, Your Honor.
During the art.
Yes, Your Honor. And Kaniel himself testified in the...
Will she be in and giving this testimony as a professional or as an observer?
I would argue that she would be, both, Your Honor. I would argue that she has been duly qualified by the trial court as an expert, and then...
It's not an opinion, though, is it? It's not an opinion testimony.
No, and as it relates to just simply observing the mother's conduct, that's not that specific testimony regarding her observations, I don't believe would be an expert opinion testimony. Now, that being said, as far as her testimony regarding the continued family therapy, whether or not that would be safe for the kids, I would argue that that would be expert opinion testimony, which is duly qualified by the trial court in this case. And back to my prior point, Kaniel himself testified in this case, and I believe he was around 11 or 12 years old at the time he testified. He specifically testified that he observed his mother having sex in the home where he was living with the door open and exposing him to that conduct. He testified that he observed Nathaniel Johnson, who was Azalea's biological father, and his mother doing drugs in the home while he was present. He testified that his mother instructed him to lie to the police on several occasions, including one such occasion in which his mother rolled over on his baby brother, which ultimately resulted in the child's death. And Kaniel finally testified that he would rather live with anyone other than his mother. It's worth noting for the court also that Kaniel, as well as Azalea, have been residing with my clients for over 6 years at this point in September. And with that, I think I will yield the remainder of my time. I feel that there's plenty of clear and convincing evidence, as well as numerous statutory grounds which were proved by clear and convincing evidence justifying the termination of the parental rights in this case. I'll yield the remainder of my time.
Here from counsel for appellant rebuttal.
Yes, Your Honor. I don't remember the exact spot where that was said. If counsel says that, I would say that that's probably true. I would have no reason to dispute that. I would just bring up the issue of the ethics with Ms. Gray. So sorry, I keep doing this. Ms. Gray, the ethics with Ms. Gray is that she had said that she was my client's counselor. So that was the issue of who was she counseling and who she was not. That was where the line of questioning, if you go into the transcript, became an issue about whole ethics. It was not the ethics of specifically what the counseling session was. It was the ethics of who her client was and whether or not she understood who her client was. And I know that might be sounding like it's splitting hairs, but that's what it was in regards to. And other than that, that'd be all for me, Your Honor. Thank you.
Court's thanks to counsel for both sides. We appreciate your arguments and your briefs on this. If you would, please recess court until 1:30 this afternoon.
This honorable court of Tennessee